Rain slammed against the windshield so hard that Ava Mercer could barely see the courthouse steps. Then her phone buzzed again. Another message. Another stranger calling her a liar. Another retailer canceling her products. 11 days earlier, Ava had been running a growing skincare business in Pasadena. Now she was standing outside a Los Angeles courthouse, watching her reputation collapse in real time because of one viral video. Inside, her attorney Daniel Su was waiting near security with a thick case file under his arm. "She posted again last night," he said. Ava swallowed. "What now?" She repeated the contamination claim. That claim had destroyed everything. Lena Vale, a beauty influencer with hundreds of thousands of followers, had published a calm, polished video accusing Ava's company of knowingly selling contaminated skincare products, ignoring customer injuries, and faking positive reviews. None of it was true, but online, truth was slow. Outrage moved instantly. They entered Department 48 together. Across the aisle, Lena sat beside her lawyer, Martin Keene, looking composed and camera-ready, as if she were attending a brand event instead of a court hearing. The clerk called the case, Mercer Botanics, LLC versus Vale. Judge Eleanor Prescott entered. The room stood, then sat. Martin rose first. "Your Honor, my client's statements were protected speech." She was commenting on consumer safety and expressing opinion based on information available to her. Daniel stood next. "Criticism is protected, Your Honor. False factual accusations are not." The defendant did not say she disliked a product. She stated, as fact, that my client knowingly sold contaminated goods, ignored injuries, and manipulated reviews. Those claims were false, and they caused immediate commercial harm. Judge Prescott looked down at the filings, then back at counsel. "The issue today," she said, "is whether the plaintiff has shown enough evidence for this case to continue." Daniel submitted independent lab reports, manufacturing audits, customer service records, and screenshots of Lena's posts. He also submitted emails showing canceled contracts and lost distributors in the days after the video went viral. Martin argued that Lena had spoken about a matter of public concern. Daniel answered that public concern did not protect false factual statements presented as truth. The judge paused for several seconds. Then she said, "Calling a statement protected speech does not automatically make it opinion." Ava held her breath. "The motion is denied. The case will proceed." Ava closed her eyes for one brief second. It wasn't victory, but it was the first time someone with authority had looked at the lie and refused to excuse it. Outside the courtroom, cameras were waiting for Lena. Ava walked straight past them. Over the next 4 months, the case became a slow, surgical dismantling of the story Lena had told online. Daniel's team issued subpoenas, collected records, hired experts, and took depositions. And piece by piece, the accusations fell apart. Under oath, Lena admitted she had never obtained an independent laboratory report before posting her video. She had relied on anonymous direct messages, an unverified screenshot from an online forum, and assumptions based on rumors spreading through the beauty community. She had not contacted Ava before accusing her publicly. She had not reviewed the company's manufacturing records. She had not confirmed that any contamination existed. She had posted first and investigated never. Then came the message that changed the case. 2 weeks before trial, Daniel obtained internal communications from Lena's management agency. In one message, sent the day before the viral upload, Lena wrote, "This one is going to explode. Even if she threatens legal, the traffic will be worth it." When Daniel showed Ava the message in his office, she stared at it in silence. Not because she was shocked, because she finally had proof that the destruction of her business had been treated like a content strategy. The trial began on a Monday morning, under bright courtroom lights that made everyone look pale and exhausted. Daniel's opening was simple and precise. "This case is not about silencing criticism," he told the jury. "It is about false statements presented as facts." The defendant accused a real business owner of knowingly endangering customers. She did so without proof. And the damage was immediate. Martin's opening leaned on free speech. He portrayed Lena as a consumer advocate, raising concerns in good faith, not a malicious liar. The jury listened carefully. Ava testified first. She described building Mercer Botanics from scratch, starting with handmade test batches and local weekend markets, before eventually getting her products into independent stores across Southern California. She talked about years of work, the trust of repeat customers, and the pride of building something slowly and honestly. Then Daniel showed the damage. Refund requests surged, distributors withdrew, orders disappeared, staff hours were. Ava's voice tightened only once, when she described telling her small team that she could no longer promise stable payroll. "I could survive criticism," she said. "What I couldn't survive was a lie delivered as a warning." The plaintiff's toxicology expert testified that the products named in Lena's video did not contain the contaminants she had claimed. A digital forensics analyst testified that some screenshots used in Lena's posts lacked reliable origin data and could not be authenticated. A damages expert testified about the economic harm to the business. Then Lena testified. At first she looked controlled, even sympathetic. She told the jury she believed she was helping consumers and acted out of concern. Daniel approached the cross-examination without raising his voice. "You told your audience that Mercer Botanics knowingly sold contaminated products. What verified lab report supported that statement?" Lena hesitated. "I did not have a verified lab report at that time. You said Ava Mercer ignored injury complaints. How many injured customers did you personally interview?" "None." "You said the company manipulated reviews. What evidence did you have?" "I had reason to suspect." Daniel in gently. "What evidence did you have?" Lena looked at the jury. No direct evidence, and in that moment, stripped of editing, captions, and social media performance, the case became painfully clear. This was not courage, it was recklessness, amplified by influence. In closing, Martin again warned the jury not to punish speech. Daniel answered with calm force. "Speech matters," he said. "That is why facts matter. Influence does not replace evidence. Reach does not excuse recklessness. A person cannot destroy a business with factual accusations they never verified, and then call it opinion after the harm is done." The jury deliberated for 6 hours. Ava waited in the hallway outside the courtroom, staring at the floor tiles, while every footstep made her heart jump. When the clerk finally called everyone back in, the courtroom felt colder than before. The foreperson stood. On the claim of defamation, the jury found in favor of the plaintiff. Compensatory damages, $18 million. Punitive damages, $750. Ava lowered her head. The money would not erase the panic, the lost months, or the stain left on her name. Online reputations did not heal overnight. Search engines remembered everything. But now the official record said what the internet had refused to say. The accusation was false. After the hearing, Lena left without looking at Ava. Outside, late afternoon light washed the courthouse steps in gold. Reporters shouted questions. Cameras turned. Microphones rose. Ava stopped halfway down the stairs. She had imagined this moment many times. In some versions she said something sharp. In others, triumphant. Instead, she said only this: being online does not make a person less real. And being influential does not make a lie less harmful. Then she walked away. That night, alone in her office, Ava stood beside the shelves of products she had fought to defend. The air smelled faintly of paper, glass, and lavender. On her desk lay the signed judgment. What happened to her was bigger than one lawsuit. It was a warning about the world people now live in. A world where speed often defeats truth, and confidence can sound like proof. But California law still draws a line. Under California Civil Code Section 45, libel is a false and unprivileged written publication that harms someone in their occupation or reputation. And while California's anti-SLAPP law protects genuine free speech on public issues, it does not automatically shield false factual accusations when evidence shows the plaintiff is likely to win. That was the lesson at the heart of Ava's case. People are free to speak, but they are not free to invent facts that destroy another person's livelihood. Online, a lie can spread in hours. In court, it still has to survive the truth. And although justice may take longer to arrive, it always falls heavily on those who dare to challenge it.